The small estate affidavit in North Carolina. What is a small estate affidavit? A small estate affidavit is a sworn statement of a person who considers themselves eligible for getting inheritance by the descendant who left assets of value less than a state's statutory limit. The document is considered an option for those whose close ones died not owning enough property to qualify for probate according to their state laws. The affidavit might also be used by the creditor of the descendant proving the debt on oath before the court. A small estate affidavit might concern any property left by the descendant: bank accounts, jewelry, art, vehicles, money, and real estate in some cases. Typically, a small estate affidavit is used when there is no last will. However, some states allow the use of an affidavit in conjunction with the last will, depending on certain legal requirements. In all states, such a document requires attestation by a notary public or other official authorized to administer oaths. Why do I need a small estate affidavit? If your spouse or parent has died, such a document will help avoid long probate court proceedings and associated costs and take possession of the property left by your close person immediately. Having the affidavit form accepted by the local probate court, a claimant can require a bank or other entities or people who currently possess the estate previously owned by the descendant to give it away to them. However, in certain situations, it would be wise to first seek legal advice before filing the small estate affidavit form. For example, when the beneficiary has not reached the age of majority or is disabled. When chances of a will contest are quite high. When the descendant has left unpaid debts. Or when it is impossible to create a comprehensive list of the descendant's property and assets. A few words about a small estate affidavit process in North Carolina. In the state of North Carolina, the maximum value of personal property cannot exceed $20,000 or $30,000 if a spouse is the affiant. The descendant's property transferred in such a way might include motor vehicles and real estate. An affidavit can be filed no earlier than 30 days after the death of the descendant. At the same time, no application or petition for the appointment of a personal representative should be pending or be granted in any jurisdiction. For the document to be accepted by the probate court in the North Carolina county where the descendant's estate is being handled, make sure to have prepared a death certificate, the original will, if any, a properly filled affidavit, a sample of which can be found on the North Carolina Judicial Branch website. If the court accepts the document, you will receive a court-certified copy of the small estate affidavit. It will let you get the rights to the property mentioned in the affidavit.